Salamat, Mr. Witness. Salamat, Mr. Presiding Officer.
Thank you, Senator Judge
Mag-round
Risa.
3 po ako kung meron po. Salamat.
Let's try to finish the interjections of Senator Judges before we pause for lunch so that we can resume with the new witness of the prosecution after lunch. Senator Judge Rafi Tulfo is recognized. Thereafter, Senator Judge Villanueva for the availment of round 2. You may proceed, sir, when you're ready. You have 2 minutes.
Thank you, Mr. Presiding Officer. Mr. Witness, sa panahon na kung saan kabilang ka ng ICFAO at ikaw ay mga nag-audit ng mga ahensya ng gobyerno, meron ka na bang, bukod sa OBP at saka sa VPSARA, meron ka na bang ibang agency ng government na na-issue niyo ng disallowance?
Sa pagkakalam ko, meron na po.
Ano itong mga agency na ito?
Hindi ko po pwedeng i-disclose. Your
Okay.
Honor.
At bakit? Bakit sila na-issue ng disallowance?
Dahil yun nga po, since ang basis lang po namin ay yung joint circular, hindi po compliant dun sa provisions ng joint circular.
Hindi compliant. Okay, so nung na-issue ng disallowance yung office ni VPSARA, ano yung naging tugon nila?
Wala na po akong personal knowledge, Your Honor, kasi wala na po ako sa ICFAO.
Okay. Nabanggit mo rin na ikaw nga'y pinuntahan sa tanggapan mo sa COA para magkaroon ng tinatawag na audit query. Yan bang kauna-unang pagkakataon lamang na meron government agency na pumunta sa opisina mo para makipag-usap sa'yo?
May mga agency po na nagtatanong, nagsisik po ng clarification with respect to the provisions of the joint circular. Pero yung OBP po yung first time na nag-ask po ng audit query.
OBP?
Yes po.
Okay. Noong mga panahon na pumunta sila sa inyong tanggapan, pinanganak na ba doon si Mary Grace Piatos? Hindi pa. Meron na bang Grace Piatos noon?
Hindi, wala po doon sa submissions nila po, Your Honor.
Wala pa. Okay. Nung puntahan ka ng Chief of Staff ng OVP at saka yung si Attorney na nandito ngayon, nakalimutan ko yung pangalan niya. Ayoko na pangitin. POA. Were you intimidated?
Wala naman pong ganun, Your Honor.
Good. And yun yung isang unang pagkakataon na sabi mo kanina na may pumunta doon para makipag-usap tungkol sa audit query.
Yes po.
Okay. Anyway, nothing personal to sa'yo, attorney. You're a good lawyer. As a matter of fact, dati nakausap ko siyang meron pong programang Wanted sa radyo, may problema tungkol sa DepEd, and I call him at sumasagot naman siya. At yung mga sinasagot niya sa akin, okay naman. And for that, hanga ako sa'yo. Doon lang sa programang Wanted sa radyo na mabilis kang lapitan at natutugunan mo yung mga problema na nilalapit ko sa programa ko. Thank you. Thank you.
Thank you, Senator Judge Rafi.
Mr.
Senator
Chair.
Judge Joel.
Mr. Presiding Officer.
Yes, what is the pleasure
I
of
don't know if
counsel
this
for
is in order, so I would just like to ask if you would allow me to do so. But since I've always been, I was alluded to and references were made to the meeting. If you could just give me maybe 2 minutes to just give context to that meeting. But if I'm not allowed to do so, then I will submit to the ruling of the presiding
Unfortunately, counsel, no. That's why I also prohibited them from questioning you or
Yes, okay.
alluding to you in relation to any question.
I
You will
understand.
have the appropriate opportunity during your presentation of evidence in chief, if you do so, if you want to explain that meeting. Although I watched you trying to explain it yesterday already, which I will address later. But we will cross the bridge when you present your evidence in chief, Attorney Pao. You will have your chance.
Thank you. Thank you. I respect that, Mr. Presiding Officer.
Senator Judge Villanueva, you have 2 minutes, sir. You may proceed when you're ready.
I'll help a bit. Is there anything illegal, improper to that meeting, Mr. Witness?
Wala naman po since
you.
may mga agency naman po na nagtatanong din po sa amin.
Thank you. Sa item 4 ng Feb 1 na AOM na ginawa po ninyo, sabi po ninyo masyadong general ang socio-economic program delivery at hindi ito tinukoy yung specific confidential activities. Ano po yung minimum level na of detail na dapat ay nakasaad po doon sa PFP o yung physical and financial plan upang makapagbigay po ng ito ng tunay na authority at spending limit at hindi naman na inilalantad yung sensitibong operational information?
Based po dun sa joint circular, dapat naka-indicate po dyan yung specific programs, activities, and projects po na pagbabasehan ng kanilang confidential disbursement po. Yung specific confidential activities po na kanilang pagbabasehan, since yan po ay plano, dyan po nakabase yung kanilang confidential expenses.
So the PFP is not merely a reporting form.
Yes po. Yan po yung basis for disbursement.
Dapat po bang approve at sufficiently detailed yung PFP bago ilabas o gastusin ang confidential funds? Kung magbigay lamang po ng mas detalyadong paliwanag, for example, pagkatapos magastos yung salapi, maaari po ba nitong retroactively ma-cure ang kakulangan dun sa PFP? Sa original PFP?
Pwedeng pa ulit po ng tanong, Your Honor. Sorry po.
Ulitin ko lang Dapat po bang approve at sufficiently detailed na yung PFP bago ito ilabas o gastusin ang confidential funds? At kung nagbigay po sa pagkakataong ito ng mas detalyadong paliwanag pagkatapos magastos ang kakulangan sa original PFP?
Maaari po, Your Honor.
So makukure siya. Ngunit hindi ito nagawa. Kaya po natuloy yung AOM, kaya natuloy dun sa NS.
Yes po.
Nabanggit po ninyo na limitado yung space sa accomplishment report, kaya hindi po maipaliwanag ng ahensya kung ano talaga yung bawat purchase o expense. At dahil dito, tama po ba na hindi dapat ibase lamang ng COA yung kanilang findings doon sa broad labels lamang at kailangan suriin muna ang bawat transaksyon at supporting document?
Yes po, Your Honor.
Doon po sa 82 million na medical and food aid, 20 million na incentives of traveling, sinuri po ba ng COA ang bawat purchase at payment? Alin po dito yung supported at allowable sa ilalim ng item 4.8 at alin naman po ang unsupported o hindi allowable?
Ang pinagbasehan po namin ng findings yan is yung sinamit po nilang documentary evidence of payments po. Doon po namin in-evaluate if compliant ba yung si OBP dun sa requirements ng joint circular.
At alin po yung supported at allowable at yung hindi?
Wala pong data as of this moment po.
So you agree, sir, yung broad labels ng medical and food incentives do not by themselves show the nature.
May apologies, Your Honor, pero yung sinabi niyo po pala na provision of medical and food data, yung payment of incentives or traveling are per se, hindi po siya among the allowable expenses po.
Yun yung tanong ko.
Under
Thank you.
4.8.
Paki-explain nga po pa.
Dahil yung enumeration po under 4.8 na allowable expenses ay exclusive po. So kapag hindi po kasama doon yung kanilang expenditure, hindi na po siya allowed as confidential expenses po.
So yung limited space in the accomplishment report may result in incomplete or overly broad descriptions. Would you agree?
Yes po.
Kaya yung relevant question, Mr. President, is not whether the entire category was allowable or disallowable. The COA should be able to identify, at nabanggit po ng witness natin, to identify the specific transactions and amounts that were supported, unsupported, or outside the allowable purposes.
Yes.
Tama po yun.
Yes po.
Magwawakas lang po ako, Mr. Presiding Officer, by saying, again, and I pounded this a while ago, importante na may independent, verifiable powers ang COA, hindi lamang dun sa documents na sinesend po sa kanila. Just to share my experience when I was in TESDA, dun sa, before the AOM came out, yung pong scholar, for instance, tinawagan po yung scholar, hindi ho makontak, nagpalit ho ng telephone number. Sabi, ghost na agad. So, ang hirap po nun. But dun sa AOM, prove, kaya hindi nag-issue ng notice of suspension because natuntun yung scholar. So, I hope that is very clear and would help our Commission on Audit in doing their job more efficiently. Thank you very much, Mr. Witness. Thank you, Mr. Presiding Officer.
Senator Judge Lacson, for his interjections, you may proceed when you're ready, sir. You have 2 minutes.
Within 2 minutes.
Thereafter,
Mr.
Senator
Presiding
Judge Padilla.
What is your level or security clearance level? Top secret being the highest, access sa documents, saka information, restricted being the lowest. Meron ka ba security clearance na grant o na-issue para sa'yo?
Wala naman.
Well, you know, I assume na mataas yung security clearance mo kasi ang hinahawakan mo, ino-audit mo, confidential information, confidential funds, di ba?
Yes po, Your Honor.
So I wonder why wala ka security clearance. Kasi paano ka mag-audit? Kasi pag may intelligence project, naka-vault yan eh. Lahat ng aliases, yun ang nakalabas. Pero yung tunay na identities corresponding to the aliases, naka-vault. Pag declassified na, terminated na yung program, yung activity o yung project, intelligence project, pwede na ilabas yun kasi declassified na yun. So kung wala kang security clearance, paano ma-access? Yung tulad na sinabi ni Senator Subiri, quarterly, nagpapadala sa Senate President, Speaker of the House, ng intelligence and confidence, paano ginastos? Kasi may oversight powers kami, di ba? So paano ka makakapag-audit properly kung hindi mo alam yung nature ng intelligence project or operation? Kaya kanina tinatanong ko, yung bang evidence of success per activity, ano ba, after surveillance report? And mind you cannot call it successful kung negative yung surveillance. Wala nakita eh, pero gumastos ng pera yon. So would you consider that another topic as a success or evidence of success, maski negative yung resulta ng intelligence information gathering, operation or activity, or yung after surveillance report? So kung walang result, negative, ano yun, hindi successful? Hindi pwedeng i-clear?
Nakalagay po kasi yung nature ng item is payment of reward. So dapat...
No. Pagka kasi nag-acknowledgement receipt, no? Halimbawa, bumiyahe, meron ding informant yung informant, ginasusan, o bumili ng sigarilyo sa sari-sari store, nagkape, kasi kausap yung informant. Wala ka makikitang... Oh, thank you, Mr. President.
Kindly wind up, Senator Lacson. Pati ako nabitin eh.
You may just respond na lang. We'll wait for your answer.
Ay, sorry po. Pwedeng ko ulit.
Ulitin ko hindi lahat ng after surveillance report successful. Negative eh. Wala nakita. Pero gumastos.
Oh.
Hindi lahat ng intelligence gathering information successful. Kasi negative. Pero may gastos yun. How would you classify that? Evidence of success ba yun o hindi? These are practical questions Kasi galing ako dyan eh. Kaya alam ko yung kalakaran.
Opo. That calls for...
Yun nga wala ka security clearance kasi. Kasi naka-bolt lahat yan. Pagka intelligence project, naka-bolt. Pag declassified, terminated yung project, saka ilalabas yun. Nandun lahat yung mga tunay na pangalan ng mga aliases.
Opo.
Kumuha ka ng security clearance. Hindi, wala nga raw.
Next to interject would be Senator Judge Padilla. You may...
Kapamahalang hukom. Susundan ko lang po yung mga tanong ko kanina, kabayan, Nueva Ecija. Opo. Yung una pong cheque ay 125 million December 20, 2022. Tama po ba?
Yes po, Your Honor.
Opo. Batid niyo po ba na ang founding anniversary ng CPP-NPA ay December 26?
Wala po akong personal knowledge about that, Your Honor.
Opo. Dahil wala po kayong katulad ng sinabi ni Senator Lacson, wala po kayong clearance, ano? Pangalawa, second check po, 125 million, January 31, 2023, tama po?
Yes po, Your Honor.
Opo. Ang NPA founding anniversary po ay March 29. Batid niyo po ba yun?
Wala po akong personal knowledge about that,
Okay.
Your Honor.
Third check, 125 million, April 18, 2023. Tama po ba?
Hindi ko po matandaan yung date po ng check eh. May I refer po to the check po.
Stopwatch, please. April 18, 2023 po, yung 125 million.
Yes po, Your Honor.
Opo. Ang 50th po, golden anniversary ng NDF, National Democratic Front, ay April 24. Kaya ko po nabanggit lahat to. Ito pong mga dates na to, nung December 26, March 29, April 24, lahat po ito, walang nangyaring attack. Lahat po foiled. Wala po. For the first time, wala pong nangyaring attack. Kasi tuwing founding anniversary, may attack. Ang tanong ko po, Ginoong Kabayan, naniniwala po ba kayo na malaki ang papel ng confidential fund at confidential agent?
Depende po yan sa kung ano po talaga yung mandate ng agency po, Your Honor.
Alam naman po natin na ang DepEd, diyan po nanggagaling ang tinatawag naming sa Communist Party po, ano? Meron po kasing pangkat gerilya, ang pangkat politikal. Yung pangkat politikal, yan po yung mga estudyante na nanggagaling sa universidad. Sang-ayon po ba kayo doon?
I cannot answer that po, Your Honor.
Okay, dahil wala nga po pala kayong clearance. Maraming salamat po.
Thank you, Senator Judge Padilla. Before I let you go, Attorney Wamil, just to continue on the points I raised earlier, and to clarify it for the Senator Judges, under 8.3, dapat may failure to liquidate at demand bago maging prima facie. Tama po ba?
Yes po, based on the provision po.
But the provision simply cites what? Ano po yung basis ng 8.3?
The, jurisprudence po, Your Honor.
Hindi lang jurisprudence, hindi ba? Kino-quote ng jurisprudence ng Martinez ang Article 217 ng Revised Penal Code for malversation. If you read Martinez, that's the jurisprudence cited by 8.3.
Hindi ko na po maalala yung Martinez case po.
Yun po yung nakalagay na kaso sa ilalim ng 8.3 na sinasite nyo po mula nung simula pa kayo magtestigo. Nakasad po yun doon. Gusto nyo tingnan.
May I
Kindly
refer po?
give him the joint memorandum circular which he has been quoting from since the beginning.
Based on this provision po, yes po, Your Honor.
You've been quoting 8.3 the whole day yesterday and today, so I guess you should know the basis. The Martinez ruling of the Supreme Court, which in turn only cited Article 217 of the Revised Penal Code. Are you aware of that, Attorney Wamil? Which basically says na may prima facie para mag-file ng information ng Sandigan Bayan laban sa isang opisyal. Yan po yung kasong yan, hindi po ba? Are you familiar?
Hindi ko na po ma-recall po, Your Honor.
Now, to go to the details, failure to liquidate. Pag may AOM po bang in-issue, failure to liquidate na yon? Yes or no?
No pa po.
Pag nakadalawang AOM, failure to liquidate po ba yon? Hindi pa rin.
Hindi pa rin po.
Pangatlo hanggang panglimang AOM na kulang pa rin yung sinasubmit, may failure to liquidate na po ba? Wala pa rin.
Wala pa rin po.
Pag nag-notice of suspension, may failure to liquidate na po ba? May failure to liquidate na po ba sa inyong interpretasyon? Dahil auditor naman kayo, kapag ka nag-issue na ng notice of suspension.
Based on the definition po kasi ng notice of suspension, nakalagay po doon na it appears that the disbursement is illegal, irregular, or improper. So
It appears, but is it within the purview and definition of failure to liquidate according to your interpretation? Failure to liquidate na po ba yun? Hindi pa.
yes po, Your Honor, failure to liquidate.
Sa pananaw nyo, pag may notice of suspension, failure to liquidate na. Notice of disallowance, failure to liquidate?
Yes po, Your Honor.
Ngayon, failure to liquidate pa lang po tayo. Kailan nagiging final yung mga yan? Failure to liquidate. Yung finding na failure to liquidate.
Kapag nag-appeal po and then nagkaroon po ng resolution si Commission Proper at nagkaroon po ng final decision.
final and executory na po siya immediately or after X days?
Pag nag-final decision na po, yes po, final and executory na po siya kaagad.
Immediately?
Yes po, pag naglabas po ng decision si Commission Proper, yes po.
Paano po pag inapila sa Korte Suprema?
Ang basis naman po ang ground naman po nung petition for certiorari is a grave abuse of discretion.
So?
Pero ang nakalagay po sa aming rules po kasi, from the moment na magkaroon ng final decision, pwede na po siyang i-refer to the Office of the Ombudsman for the filing of the criminal
Hindi ko
charge.
sinasabing pwede nang i-refer o hindi. Hindi ko rin sinasabing bawal maging subject matter ng impeachment. Ang tinatanong ko lang po, final na po ba yon? Meaning may failure to liquidate na at final na yung finding na yon o hindi pa kapag inapila sa Korte Suprema? Your Attorney Wamil, come on po.
Kasi based on my understanding po, since yung final, kapag nag-issue po ng final order si Commission Proper ng COA, since yun na po yung time na pwede mag-file ng charges, na criminal charge, mag-endorse po for the filing of criminal
Hindi
charges.
po
sa
filing
Ombudsman.
ang tinatanong ko. Ang tinatanong ko kung final na po o hindi sa pananaw ninyo. Ang usapan natin kanina, nung tinanong ko kayo, di ba?
Yes po.
Executory siya, maliban na lang kung may TRO, pero hindi
Yes,
pa final yung decision.
Yes po, Your Honor.
Pero tama ka, pwede mag-file dahil ang requirement lamang naman para mag-file ay prima facie.
Yes
Diba?
po, Your Honor.
Yun nga yung sinasite yung kaso sa Martinez.
Yes po.
At kaugnay naman po ng demand, ang AUM ba may demand?
Yes po, since ni-require po yung agency to comply, to submit.
Yung po ba yung sinasabing demand sa 8.3? Mag-comply o magbayad? Hindi po ba ang requirement ng 8.3 ay mag-restitute na, hindi mag-comply?
Ang nakalagay po kasi dito, liquidate po. So yung submission po ng liquidation requirements.
Nakalagay po ay failure to liquidate is prima facie. Failure to liquidate and upon due demand is prima facie. Di ba?
Yes po, Your Honor.
May demand ka ba sa AUM mo?
Yes po.
Saan nakalagay dun? Saan po nakalagay sa AUM yung demand?
Doon sa last paragraph po na hinihingi yung comments and to submit po the supporting documents.
So hindi restitution yung pinag-uusapan natin nito. Demand to submit documents.
Yes po. Yung restitution po, Your Honor, kapag may ND po, may notice of disallowance na na-issue.
So basta may demand, so sa AUM mo may demand na pero wala pang failure to liquidate. At ang definition mo ng demand is demand to liquidate, hindi
To
po
submit the documents
mag-restitute.
po. Yes po, Your Honor.
Tama po?
Yes po, Your Honor.
So sa puntong ito, sabi mo may alam kang notice of disallowance na kung walang appeal ito, final na yon pag hindi pumasok sa period of appeal.
Yes po, naging final na executory po siya, Your Honor.
Finally, as a lawyer, if it is appealed to the Supreme Court under whatever relevant rule, 45 or 65, as a lawyer, does that make the decision of the COA final or does that mean it's not yet final until unless ruled upon by the court with finality?
Yung decision po kasi ng COA ay may different aspects. Meron po yung i-restitute, kung i-endorse po dun sa Ombudsman for filing of criminal charges and admin. Yung obligation to restitute po kasi kapag naging final na po, on the level pa lang po ng COA, ay dapat na po siyang bayaran. Even if there is a pending petition with the Supreme Court, hindi po siya may stay unless may TRO po.
Unless nga may TRO.
Yes po, Your Honor.
Thank you, Attorney Wamil. Thank you, Mr. Witness. You don't want to have lunch yet, Senator Judge Risa? Yes, Senator Judge Risa, before we break for lunch. One question each from Senator Judge Pangilinan as well before we break for lunch and move on to the next witness. Yes, Senator Judge Risa.
Salamat po, Mr. Presiding Officer. Mr. Witness, isang huling tanong na lamang po. Sa Government Accounting Code, sino po ang mga opisyal na tinuturing na accountable officers?
Under the Government Accounting Code, yung disbursing officer, yung accountant, yung treasurer, yung project officer, and the head of the agency po.
At tama po ba na under this law, sa sections 101 at lalo na 102, ang head of agency ay primarily at immediately responsible para sa pondo sa kanyang ahensya.
Yes po.
At salamat po, Mr. Witness. Salamat,
Senator
Mr.
Judge
Presiding
Pangilinan.
Officer.
Yes, one or two questions, Mr. Presiding Officer. Dun sa 10 taon mong karanasan bilang auditor ng mga confidential funds, lahat ba ng 30 ahensya ng pamahalaan inuubos yung naka-allocate sa kanilang pondo?
Meron pong iba na hindi po.
Merong iba.
Yes po.
So merong nauubos.
Yes po.
At dito sa mga hindi nauubos, saan napupunta?
Binabalik po nila sa National Treasury.
Okay. So dito kasi sa 3 quarters, puro ano yun, no? Ubos lahat, no? 2022, 2023 first quarter, second quarter, diba? Yung mga inaudit mo, ubos lahat, di ba?
Based on the documents po, yes po, Your Honor.
Yes, okay. So, pero merong mga ahensya hindi inuubos.
Yes po, sa pagkakalala ko.
Dito naman sa usapin nung, sorry. Itong usapin ng finality, nabanggit ni Presiding Officer. So, pagka nasa pending sa Supreme Court, hindi pa final, no? Ngayon, kung halimbawa sa AOM sinubmit na ng Office of the Vice President at DepEd yung kompletong dokumento, walang problema, hindi ba?
Wala na pong problema, Your Honor.
So wala nang tutuloy sa notice of suspension.
Yes po.
Kung after the notice of suspension, nag-submit ang OVP ng lahat ng kinakailangan dokumento, di tapos na ang boxing, ika nga, wala nang problema.
Yes
Tama?
po, Your Honor.
And the same, from notice of disallowance, pwede pa bang isubmit, mag-reconsider, tapos isasubmit lahat ng dokumento na nararapat?
Pag notice of disallowance po is mag-a-appeal na lang po or to settle yung remedies po.
Yes.
Hindi na po yung submission lang po ng documents.
Appeal sa en-bank.
Sa higher authority which is the commission proper po.
Yes. And then, doon, pwede rin dokumento. Maaari, hypothetical, di ba?
Kapag inalaw po sila, Your
Yes, at upon with the leave of the commission, di ba? At pag nasabit lahat ng mga pertinent documents, wala nang problema, no?
Yes po, Your Honor.
So in other words, ang usapin lang talaga rito isabit yung mga tamang dokumento. Tama?
Yes po, Your Honor.
And I would assume, pagdating sa Korte Suprema, dahil pending halimbawa sa Korte Suprema, pag sinabit lahat ng dokumento ng OVP para patunayan na talagang ginastos ng tama ang pondo, walang problema, hindi po ba?
Yes po, Your Honor.
So dokumento, ebidensya ng dokumento ng gastos ang usapin dito para mawalang sala o hindi matuloy itong mga disallowances ng COA
Yes po, Your Honor.
na nagkakahalagang magkano?
Disallowance po. Hindi po ako
Sorry,
alam
pero
po ang
yung
personal knowledge dun sa amount.
yes, about 300 I forget, no, pero 3 quarter 'yun, ano? 375 million.
No, for the OVP, Senator Judge Pangilinan, I think the notice of disallowance only pertains to about 73
For the OVP.
million. Only for the last quarter.
Yes, for the
Wala
last
pa namang
quarter.
ND lahat ng quarters eh. Sa
No
pagkakaalam ko,
disallowance
hindi pa pinapresenta.
pero may mga suspension.
Yes.
But we're
Hindi
talking
pa
of
pinapresenta.
about several hundred millions na kung masamite lang yung tamang dokumento, wala tayong issue.
Yes po, Your Honor.
Thank you.
Thank you, Senator Judge Pangilinan. Attorney Wamil, salamat po sa inyong oras at panahon at kooperasyon at pagsagot sa aming mga katanungan na may buong pasensya at katapatan sa abot na inyong nalalaman. You are excused, sir, and thank you very much.
Thank you.
We shall pause for lunch and shall resume at 1 p.m. where we expect the counsel for the panel of prosecutors or the panel of prosecutors to present their next witness in the person of Ms. Eileen May L. Del
F, which is the response dated April 19, 2024, Your Honor. This is Defense Exhibit 1-115, Office of the Vice President and Series.
Attorney Christine,
I'm sorry, Your Honor. Can I confer with my
you may do so.
counsel? We do not stipulate, Your Honor.
Proceed, counsel. Attorney Kapunan.
Next, Your Honor, we have acknowledgement receipts for the periods February 6 to June 30, 2023, and April 25 to June 30, 2023. For the appreciation of this honorable court, Your Honor, this is exhibits P-1-8-850 to P-1-8-1714, representing the first quarter documents of the Office of the President and the second quarter documents of the Office of the Vice President. The first quarter is 519 documents. The second quarter is 530 documents, or a total of 1,049 documents, Your Honor.
Counsel, the copy you gave me is different from what you just read. The copy I have is exhibits P1-8-849 to P1-8 to 1898. And it covers ARs for the period February 6 to March 29, 2023 for the first quarter, and April 25 to June 30, 2023 for the second quarter. That is different from what you are showing on the screen, Counsel.
Yes, Your Honor. My bad. It's what is flashed on the screen, Your Honor. The presiding officer is correct, Your Honor. But in any event, these are the same number of documents, totaling 1,049.
I bring that up, Counsel, because that is, I guess, the same copy that Counsel for the respondent has, what I have. Would that be correct?
No, Your Honor. We have our own copies of the
No,
exhibits.
do you have
which
the
is
same? Is the copy that Counsel for the panel of prosecutors? Is it
Yes,
the same
yes.
copy?
The list, Your Honor, yes.
The
We
same
confirm
copy as
that.
the presiding officer has, not the one flashed on the screen.
Yes, Your Honor. I confirm that.
So you're asking for stipulation for the ones I mentioned, the ARs for the periods I mentioned, February 6 to March 29, 2023, and April 25 to June 30, 2023. Do you stipulate, Counsel?
We do not stipulate, Your Honor.
Move on, Attorney Kapunan.
Your Honor, in connection with this, as in the first witness yesterday, since the presiding officer did point us to the particular provision in the rules of court, which is Rule 130, 3C and 3D, Your Honor, with reference to voluminous documents, which would take a lot of time for this honorable court, Your Honor, summaries will be allowed to be marked. So, just to mention ahead of time
That
that
is
we
correct,
will not be
Counsel.
presenting 10,049 documents, but the summary, a tabulation prepared by this witness, Your Honor.
That is in Section 3C in relation to Section 7.
Yes, Your Honor.
The court will allow it as it has allowed it yesterday.
Thank you, Your Honor. Next is Exhibit P-1-12-G, which is a certification of the VPSPG, Your Honor. VPSPG certification dated April 4, 2024, which is Defense Exhibit 1-91, stipulated, Your Honor.
We stipulate, Your Honor.
Duly
Then
noted.
we have the Protective Intelligence Operation Report for the engagement of respondents Duterte and the Vice Presidential Security and Protection Group for the first quarter of 2023. And these are exhibits P-1-12-H up to P-12-H-9, which is Defense Exhibit 1-115 OVP and series, Your Honor. We have been told that counsel will not stipulate to this, Your Honor.
That is correct, Your Honor.
May we know the reason, Your Honor?
Your Honor, we do not stipulate on this because these documents that they marked are incomplete. Hence, they will not truthfully reflect, Your Honor, what the document is. So we do not stipulate, Your Honor.
Actually, to abbreviate the proceedings, Counsel, no reason need be given by opposing counsel. Since stipulation is a voluntary act on their part, they may refuse, and any refusal should not be taken against them as well, although it will abbreviate the proceedings. Please proceed, Counsel.
Next, Your Honor, is Protective Intelligence Operations Report for the engagements of Respondent Duterte from the Vice Presidential Security Protection Group for the second quarter of 2023, Exhibits P-1-12-M to P-12-M-13, which is Defense Exhibit 115 OVP and series, again, not stipulated upon by the defense, Your Honor.
That is correct, Your Honor.
For
Move
the
on,
court-
counsel. Duly noted. Move on.
Moving on to the third quarter, incidentally, these documents previously mentioned are for the first quarter of 2023 Office of the Vice President. We now turn on to the third quarter of 2023 Office of the Vice President. The first exhibit is Audit Observation Memorandum, or AOM, dated August 8, 2024. Prosecution's Exhibit P-1-12-I, Defense Exhibit 1-106, OVP, stipulated upon.
We stipulate, Your Honor.
Noted.
Exhibit P-1-12-J, which is the Office of the Vice President's response dated August 27, 2024. Defense Exhibit 116, OVP and series, not stipulated, Your Honor.
That is correct, Your Honor.
Exhibits P-1-8-1899 up to P-1-8-2672. Acknowledgement receipts for the period July 14 to September 30, 2023 for the third quarter. Not stipulated upon, Your Honor.
That is correct, Your Honor.
Noted.
P-1-12-K, a certification dated September 30, 2023. Defense Exhibit 1-116 OVP and series, not stipulated upon.
Counsel?
Sorry. I think
Certification dated September 30, 2023.
that is stipulated, Your Honor. Not stipulated.
I verify.
I'm sorry?
It
Not
is both
stipulated, Your Honor.
Not stipulated.
It is not stipulated, Counsel.
Yes, not stipulated.
Not stipulated.
Exhibits, thank you. Exhibit P-1-12-11 up to P-1-12-110. Protective Intelligence Operations Report. Third quarter of 2023, which is an attachment to the OVP's response dated August 27, 2024, not stipulated upon.
That is correct, Your Honor.
Notice of disallowance.
Before you continue, counsel, I remember, Attorney Christine, that you had 8 of these proposed documents for stipulation you will not stipulate on.
Actually, Your Honor,
more.
it's 10.
10.
1-17-5 to P-1-17-1229.
These are the acknowledgement receipts
Yes,
for the
Your
period
Honor.
of February 20 to March 30, 2023, and April 20 to June 29, 2023.
Correct, Your Honor.
And the last one?
And the last one is the acknowledgement receipts for the period July 12 to September 30, 2023, Your Honor. Marked as exhibits P-1-17, 1233 to P-1-17, 1894.
The rest you stipulate on,
Correct, Your Honor.
which I will read for the record. With the permission of Attorney Lorna, counsel
Your
for
Honor.
the panel of prosecutors. Counsel for respondents stipulates on the following documents. Exhibit P-1-13-F, notice of disallowance dated March 31, 2026, also marked as exhibits, the respondents exhibit 1-9. Exhibit P-1-21B, response dated April 17, 2024, marked as respondents exhibit 1-90. Exhibit P-I-22A, certification dated 11 January 2024, issued by Colonel Manaros M. Boransing II, marked as respondent exhibit 1-74. Exhibit P-I-1-22B, certification dated December 30, 2023, issued by Colonel Carlos B. Sangdaan Jr., likewise marked as Respondents Exhibit 1-75. Exhibit P-1-22C, certification dated December 5, 2023, issued by Colonel Magtanggol Panopio, also marked as Respondents Exhibit 1-76. Exhibit P-1-22D for the prosecution, and Exhibit 1-84DE for the respondent, a certification issued, undated certification issued by Colonel Adonis Bajau or Bahau. Exhibit P-1-21C, AUM dated August 8, 2024, also marked as Exhibit 1-106 OVP. Exhibit P-1-21D, response dated August 27, 2024, also respondents 1-93DE exhibit. Exhibit P-1-22E, certification dated September 25, 2023, issued by Jaicris Jan P. Mendoza. Also respondents, Exhibit 1-97DE. Exhibit P-1-22F, certification dated December 10, issued also by Jaicris Jan Mendoza. Also respondents 1-96-DE. Exhibit P-1-22G, certification dated December 12, 2023, issued by Adonis R. Bajau. Also respondents Exhibit 1-94DE. And finally, Exhibit P-1-22H, certification dated July 1, 2024, issued by Darren E. Comia. Also respondents Exhibit 1-95-DE. Would that be correct, Attorney Christine?
Yes, Your Honor. We confirm the enumeration, Your Honor.
You may proceed, Counsel.
Thank you for that, Mr. Presiding Officer. But for the better understanding of this honorable court, the acknowledgement receipts which counsel for the defense has not agreed to testify on are as follows, Your Honor. For the first quarter, for the Office of the Vice President, that's 519 documents. For the second quarter, 530 documents. For the third quarter of 2023, 774 documents, Your Honor. And if we include the 845 documents identified by Mr. Wamil yesterday, for the fourth quarter of 2022, this court will have to appreciate that counsel for the defense refused to stipulate on, well, it is the right, 2,668 documents, Your Honor. And for the DepEd, Your Honor, for the first quarter of 2023, 561 acknowledgement receipts. For the second quarter, Your Honor, 619 acknowledgement receipts. And for the third quarter, 644 acknowledgement receipts. Or to summarize, 1,824 acknowledgement receipts of the Department of Education Office, which they themselves submitted to the COA ICFAO, or a total for the Office of the Vice President and the DepEd, 4,492 documents contained in 15 boxes, Your Honor.
Hindi mo naman siguro kami tinatakot, Attorney Gaponan.
Ay, hindi po. I am,
Kindly proceed, Counsel.
and also, Your Honor, the reason I made manifestation of this is we will not present the 15 boxes. We will present, the witness will identify this, but we will be presenting in lieu thereof six summaries, Your Honor. 6 summaries prepared by this witness for the 4,492 documents, Your Honor, which will be identified in due course of the testimony together with the acknowledgement receipt, Your Honor. With the permission of this honorable court.
As earlier ruled by the court, we will allow the witness to testify from a table and or summaries given the voluminous nature of the documents that she may or will be testifying to. Counsel may proceed with her direct examination. Offer rather first.
Your Honor, please. We likewise request the following stipulations, Your Honor, in addition to these documents, that the witness has taken over the audit of the liquidation documents of the Office of the Vice President for December 21 to 31, 2022, and the first to third quarters of 2023.
Council took over from what?
From Mr. Wamil.
From December, meaning he took over.
The document has taken over the audit liquidation documents turned over by Mr. Wamil for this period, Your Honor.
Presumably when Mr. Wamil retired?
Yes, Your Honor.
Can you give the date when she took over? Mr. Wamil retired February of 2024, if I'm not mistaken.
Yes, Your Honor. February 12, 2024.
Up to today.
Up to the present, Your Honor, where he now serves in the COA Pasay, Your Honor.
What does counsel for the respondent say?
Your Honor, we cannot stipulate on that because we are not from COA, so we're not privy, Your Honor, to any of the resolutions or memoranda that were
Witness-
issued with respect to the assignment of their employees, Your Honor.
Witness can testify to that later on. Move on for other requested stipulations, counsel. If any.
That the witness is competent to testify as to the documents that they themselves, the Office of the Vice President and the DepEd, submitted by way of liquidation documents to the COA ICFAO.
Can I comment on that, Your Honor?
Yes.
We will not stipulate on that, Your Honor, because they have to establish the competence of that witness to identify the documents.
Move on, counsel.
Your Honor, we will not proceed with the other stipulations because counsel does not seem to be in the mood to stipulate this afternoon, Your Honor.
Your Honor,
It has
please.
no relation with mood, counsel.
Okay, we will now go
The
on.
counsel for the respondent is well within their rights to
Correct, Your
refuse stipulation because this is purely mutual on the part of both parties. Your time will come too. Please proceed with your with your offer, counsel.
This testimony of this witness, Your Honor, is being offered for the following. First, that Ms. Silene May L. Del Campo is a state auditor of the Commission on Audit, Intelligence, and Confidential Funds Audit Office. Second, that Ms. Del Campo was assigned to take over the audit of the OVP's liquidation of its confidential funds from Attorney Roderick Wamil, Your Honor. For easy appreciation of this honorable court, the purposes are being flashed on the screen, Your Honor. In this, well, that siya po ang nagtuloy ng inumpisahan ni Mr. Roderick Wamil na evaluation ng confidential.
Chair would just like to correct the earlier statement with your indulgence, Attorney Kapunan. Mr. Wamil did not retire on February 2024. He was transferred to another office within
Yes,
COA.
Your Honor.
Yes, please proceed.
That Ms. Del Campo evaluated the response of the Office of the Vice President to the notice of suspension dated December 13, 2023, which was issued in relation to the OVP's liquidation of its confidential funds for December 2022. Number 4, that this witness found that the response of the Office of the Vice President to the notice of suspension dated December 13, 2023 is a violation and still non-compliant with Joint Circular 2015-01. Number 5, that it was pursuant to this witness evaluation and recommendations that the notice of disallowance dated August 8, 2024 was issued by the Office of the Vice President. Number 6, that Ms. Del Campo took over the audit of the Office of the Vice President responses to the Audit Observation Memorandum dated February 1, 2024, covering the first and second quarters of 2023, and AOM dated August 8, 2024, covering the third quarter of 2023. That thereafter, a notice of disallowance dated March 31, 2026 was issued to the Office of the Vice President for the liquidation of its confidential funds covering the first to the third quarter of 2023. This witness also took over the audit of the Department of Education's responses to the Audit Observation Memorandum dated February 1, 2024. This covers the period the first quarter and the second quarter of 2023 and an AOM dated August 8, 2024, which covers the third quarter of 2023 for the Department of Education. Likewise, Your Honor, this witness will testify and authenticate such other documents and will attest to such other matters as are relevant and material to this impeachment case.
Comment on the part of counsel for respondent?
Subject to cross-examination, Your Honor.
Subject to cross, counsel may proceed with her direct when she is ready.
Thank you. Thank you, counsel. Madam Witness, can you again please state, pakisabi ulit anong pangalan natin, your age, your occupation, and other personal circumstances.
I am Silene May L. Del Campo, 36 years old, a state auditor currently assigned in the Intelligence and Confidential Fund Audit Office of the Commission on Audit.
Okay. Will you be testifying in English or Filipino or both, Madam Witness?
In both languages po.
Okay. With that permission, Your Honor. Please tell us, Madam Witness, Miss Silene, ano ba ang educational background natin?
Ako po ay nagtapos ng Bachelor of Science in Accountancy degree sa St. Louis University po.
Okay. And you said earlier that ngayon ikaw ay state auditor na ng COA ICFAO, Intelligence and Confidential Funds Audit Office, correct?
Opo.
Okay. Can you tell us, before you became state auditor to this current position, meron ka bang ibang position sa COA?
Wala na po akong naging ibang posisyon sa COA.
And when did you start therefore? You're being a state auditor of the COA, ICFAO.
Nagsimula po ako noong August 26, 2014.
August 26, 2014. Okay.
Opo.
Just to remind us all, ano ba ang functions nung COA ICFAO?
Ang COA ICFAO po ay office under the Office of the Chairperson na nagtitake charge po sa audit ng intelligence and confidential funds ng mga government agencies po.
Okay. And what are these government agencies that you have audited?
Ang mga na-audit ko po is mga local government units, government-owned and controlled corporations, at saka po mga national government agencies na kasama po dito ang Office of the Vice President at Department of Education.
When you say Office of the Vice President, who? Which Vice President specifically during your term, during your current position from 2014 to the present, which Vice President have you audited in terms of confidential funds?
Nung magsimula po ako sa COA, sa ICFAO, ang na-audit ko lang po na liquidation documents ng Office of the Vice President ay kay Vice President Sara Duterte.
Bakit siya lang, Madam Witness?
Dahil nga po from 2014 hanggang sa ngayon po, yung na-submit po sa amin na liquidation documents is sa confidential fund po ni VPSARA.
Okay. Mga sinubmit sa inyo?
Opo.
You also mentioned na nag-audit ka sa Office of the DepEd, Department of Education. Sino-sino mga secretaries ng DepEd ang na-audit mo para sa confidential funds?
Ang sa DepEd naman po, ang na-audit ko lang po na liquidation documents na nasubmit sa office namin is liquidation documents sa confidential fund ni Vice President Sara Duterte noong siya ay Secretary of Education.
Okay, bakit? Bakit si Secretary of DepEd Sara Duterte lang?
Dahil po from 2014 to present, siya lang po yung Secretary of Education na may confidential fund.
Let's go now to your current function as State Auditor of the COA ICFAO. And you started when, Madam Witness? Kailan ka nag-umpisa dito?
August 26, 2014 po.
Malalam ba? Sino ang sinundan mo sa position na ito?
Pwede pong pakiulit yung tanong?
You started with this office in August.
Opo, tama po.
And when you started in August, were there any liquidation documents of the Office of the Vice President and the DepEd in that office?
Yes po, meron po.
And did you evaluate them?
Nung umalis po si Mr. Wamil, ako na po ang nagpatuloy ng audit ng mga liquidation documents po ng Office of the Vice President at Department of Education po.
Okay. And pag sinabi mong audit, anong klaseng audit ang ginawa mo or ang ginagawa ng office mo?
Ang audit po na ginagawa ng aming opisina ay post-audit po.
Tell us again, what is a post-audit?
Sa post-audit po na ito, natapos na po yung transaksyon at paggastos ng pondo. Doon na po kami mag-audit. Pag natapos na po ang transaksyon at paggastos ng pondo.
Natapos na yung transaction, nagastos na yung pera, ino-audit nyo. Anong ino-audit nyo?
Ang ino-audit po namin is yung utilization ng confidential and intelligence fund.
Okay. Ngayon, what were these documents that Mr. Wamil left and which you took over with?
Bale po, iniwan po niya sa akin ang mga documents ng OBP for the periods December 21 to 31, 2022. Kasama na rin po ang first to third quarters ng 2023. And for the DepEd po, iniwan din po niya sa akin ang mga documents for the first, second, and third quarters of 2023.
Showing to you, Madam Witness, a tabulation. Merong ginawang tabulation si Mr. Wamil at ito po ay minarkahan natin to cover exhibits P-1-8-1 up to P-1-8-848 covering 845 acknowledgement receipts for the period December 21 to 31, 2022. If shown to you, this tabulation and the supporting acknowledgement receipts, please identify the same.
Opo.
Assisting counsels may approach from both parties.
Your Honor, may we manifest for the record that this witness, Your Honor, is going over, perusing all of these documents, 845 acknowledgement receipts.
Counsel, I thought the witness will simply peruse the table or summary of Mr. Wamil.
Yes, Your Honor. These are the documents. These are the ARs mentioned in the tabulation, which she also is looking at, Your Honor.
Okay, so not just the summary and table prepared by Mr. Wamil, also some samples of the ARs covering the 845 ARs.
She is looking currently at all of these 845 documents, Your Honor. Because, Your Honor, again, counsel for the respondent did not stipulate on these documents. Why are we so concerned about this document? Your Honor, please, for efficient use of time, Your Honor, these ARs are just being shown to the witness, Your Honor, for identification, but counsel for the respondents may certainly go over them one by one after this trial this afternoon, Your Honor.
The manifestation is noted.
Show it to the stipulate. Suspension is stipulated.
With the permission of the counsel for the parties, while the witness is perusing the acknowledgement receipts for the period covering December 21 to December 31, 2022, Chair would like to make some administrative orders to save on the court's time. On the subpoena documents which were submitted to the clerk of court on July 30, 2026, and on those that will be submitted on August 13, pursuant to the request for extension by the two aforementioned banks, namely BDO Unibank and Security Bank. We note that the clerk of court performed merely the mechanical act of receiving the submissions from the subpoenaed institutions, while the subject banks and institutions represented that the documents contained in the USB given to the court are the exact mirror of the hard copies they submitted, which are in turn accurately reflected in their respective document indices. The court has had no opportunity to confirm the same. Therefore, the presiding officer orders the clerk of court to compare the digital and printed copies of the submissions, both as of now and those that will be submitted, and to check them against the list provided for by the banks to make sure that the USBs indeed contain the hard copy submitted before the court and Toto turns it over to the parties in due course. So ordered. Hailin, kamusta ka na? Malapit ka na o hindi pa?
Your Honor, medyo marami pa po.
2 folders na.
With the permission of the council, for the panel of prosecutors as well as the council for the respondent, we will be adjourning in a few minutes for our afternoon session. So to be able to move on somewhat, the court directs that Hailene go over these documents after today's trial so that when she continues her testimony on Monday, that she can already testify as to those documents, if indeed those are the same documents that she reviewed, perused, and were turned over to her by Attorney Wamil. In the meantime, counsel, perhaps you can proceed with the table of or the summary prepared by either with Mr. Wamil or the witness before we call for adjournment. At least napakinggan natin si Ms. Hailene.
Your Honor, just a quick manifestation, Your Honor.
Yes, counsel for respondent.
Yes, Your Honor. We noted that the list of accounts, which was supposed to be prepared by Mr. Wamil, with the caption OVP, open parenthesis, December 21 to 31, 2022, close parenthesis, was unsigned and it was undated. Second, the witness is merely flipping the pages without comparing the ARs with the list, Your Honor, to check whether the ARs are the same with what was listed by Mr. Wamil, Your Honor. And the third one is that we note that the folders containing the ARs were not marked as exhibits of the prosecution, Your Honor. For the record, Your Honor.
Duly noted. However, the witness may testify as to the summary and or table if she's aware of it and if indeed it was part of the documents turned over to her by Mr. Wamil. Counsel for the panel of prosecutors.
Your Honor, we are tempted to make a counter manifestation, Your Honor. Because, Your Honor, these manifestations, Your Honor, are because of their own doing, Your Honor. But in any event,
I hope you won't give in to the temptation, counsel.
I will not. I will not, Your Honor. It's the wisdom of age. I will not.
Let's get something out
Yes,
of
Your
Ms.
Honor.
Hailene.
In fact, Your Honor, may I continue? May we continue to aid this honorable presiding officer that during the interregnum from today's proceedings until Monday, there will be other tabulations, Your Honor, and there will be other acknowledgement receipts. And we propose, Your Honor, and regret that this is not unusual, but it is necessary, Your Honor, that all of these documents, because counsel says that this witness was just flipping over them. They can do this in front of the defense counsels and us, Your Honor, for the next succeeding days, because we will be going over 4,492 documents and six summaries, Your Honor. Hopefully that we will be doing that in the next days out of court so that by Monday it will be a speedier presentation of testimonial evidence, Your Honor.
If you're converting that in, are you making a motion, counsel?
Yes, Your Honor, may we so move that we be allowed to do this, not only as respect to the last quarter of December 2022, which is suggestion of the presiding officer, but to all the quarters, quarter 1, 2, and 3 for the OVP and quarter 1, 2, and 3 for the DepEd.
Only with respect to the acknowledgement receipts.
Only with respect to, Your Honor, the acknowledgement, the acknowledgement receipts, Your Honor.
Aside from the asked for transfer of markings this afternoon, wala naman kayong mga appointment ng Webes at Biyernes, di ba?
Your Honor, can I comment
Yes,
on that, Your
counsel
Honor?
for the respondent.
Your Honor, under the rules, the witness has to identify the document in open court. The problem with their stipulation, Your Honor, is that they will be having the witness identify the documents out of court. So therefore, it is no longer part of the trial. And there's a problem when it comes to the offer. There will be a problem when it comes to their offer of evidence, Your Honor. And with regard to the counter manifestation or the statement of counsel that we want to, look at the witness while she's flipping the document, Your Honor. Precisely, that is what we are doing right now, Your Honor. So we object to the proposal that the examination of the ARs be done outside the court, Your Honor.
I think the purpose...
Your Honor, please,
counsel for Attorney Kapunan, the court views it perhaps as an opportunity to provide an avenue for possible stipulation as to the ARs that you did not stipulate on. Because if I remember correctly, the reason why the ARs presented earlier, the 845, under the witness, Attorney Wamil, was that the observation of the respondent was it was simply contained in a folder, transparency on a folder, and that there was no real sequence to it. So perhaps we can set a date for possible stipulation on the ARs, not really for the witness to confirm it, but for possible stipulation on the ARs,
Yeah.
if the respondent is open to it.
Your Honor, unfortunately, we will not stipulate, Your Honor. We didn't stipulate in the case of Wamil, Your Honor. The same position is maintained, Your Honor, in the case of this witness, Your Honor, because after the ARs have been submitted to the Commission of Audit, Your Honor, the OVP and the DepEd no longer had control over these ARs. So therefore, we do not know what were the receipts that were provided by the COA and how many receipts were given by the COA to the prosecution, Your Honor. And second, these are not common exhibits because we did not mark those documents or ARs as our own. We didn't adopt them as our own evidence, Your Honor. And third, the ARs that were presented or are being presented now by the prosecution have not been compared with our own copies, Your Honor. So we cannot determine with certainty, Your Honor, if their ARs are actually identical with our copies, Your Honor.
Counsel,
So
that is
we cannot-
precisely the opportunity the court is opening a chance for you to do so, to compare it with your copies of your ARs. Again, if you so desire. I mean, this is only for the purpose
Your Honor,
of
please,
expediting.
if I may, Your Honor.
Counsel for respondent will please respond first to the query of the presiding officer before I recognize Attorney Kapunan. Yes, Attorney Christine, so you do not want to take the opportunity to compare your copies of the ARs with their copies of the ARs as submitted to COA or as allegedly submitted to COA?
Your Honor, upon discussion with the team, Your Honor, unfortunately, we cannot do that.
Noted. Attorney Kapunan, what is your pleasure?
With due indulgence, Your Honor, now I will give in to my temptation. First, Your Honor, what is happening now could have been prevented had we done this exercise during the pretrial. When the clerk of court asked for stipulation on documents, these included stipulations on the acknowledgement receipts. That was the opportune time for the defense counsel to have examined page by page, receipt by receipt, the faithful reproduction of the COA AR copies with their own copy, Your Honor. They passed upon this opportunity. Now that we want it done more expeditiously by a motion that I have proposed, which incidentally I wish to amend, that because of their objection to it being an out of court, may we amend my motion, Your Honor, that it be done in front of the clerk of court and that the clerk of court be duly authorized by authority of the Honorable Impeachment Court to preside over the sessions, Your Honor. The same way as clerks of court, designated officers can mediate between the parties as to a possible amicable settlement or stipulation. And this will be, Your Honor, and I'm sorry, I'm seeing
Please
them
continue, Counsel.
nodding in acceptance of the motion. Unfortunately,
I think quite the opposite, Counsel, because he's not looking forward to the workload.
Your
But please
Honor,
proceed.
please. And so, if that is done, Your Honor, then we will be making more efficient use of the time of this honorable court. The marking, the identification by this witness, the comparison of both the prosecution markings.
These
and the
ARs have
defense
not been
markings.
individually marked, counsel?
They have been marked, Your Honor. As a
Counsel, for
matter
the
of
respondent,
fact-
you said they were not yet marked, the ones being showed to the witness.
No, Your Honor. They were marked already, Your Honor, but we also have our own marked copies, Your Honor.
They were marked, but you also have.
So, meaning, Your Honor, we have separate documents or ARs that were marked, Your Honor.
That is precisely my point,
Your Honor,
counsel.
please.
That is precisely my point, counsel. Before the clerk of court, this is like an extended or additional pre-trial. Perhaps this can be done before the clerk of court.
Yes,
You
Your
need
Honor.
not stipulate to all, only to those that exactly the same as your copies. It can be 10 out of 845, 844 out of 845. I do not know, really, quite frankly. But would rather give you the opportunity than litigate this in open court, piece by piece, similar to the stipulation asked for by the counsel for the panel of prosecutors. In relation to the witness viewing it or looking at it, if it is stipulated, then there is no need for her to actually peruse, go through, or look at it for long periods of time, only with respect to the questioned ones or those not stipulated to by the counsel for respondent. I think the court is inclined to allow for this one more opportunity to stipulate as to the acknowledgement receipts. Again, there is no it is not mandatory. The court is not forcing the counsel for respondent to stipulate on documents they refuse and don't want to stipulate. But since you have your own copies of ARs, and since the issue pertains to the chain of custody, after you submitted it to the COA, then the court would like to afford you the opportunity to compare it. Again, you need not stipulate on anything. You don't have to stipulate on a single one, but the court would rather give one more chance or one more time to try to do this, to save on the court's time, without prejudice, again, to the respondent or counsel for respondent saying that they refuse to stipulate because they are different from the copies that they have. Counsel?
Yes, Your Honor. Actually, we will agree to that proposal, Your Honor, but we provided, Your Honor, that we will not be forced to stipulate that the ARs are authentic, etc. And then the date and time, Your Honor, shall be mutually agreed upon by the parties.
Of course.
Of course, Your Honor. I think,
Of course, the date and time should be mutually agreed upon between Thursday and Friday.
Your Honor, please, you asked for it.
Because
Your
insofar
Honor,
as
please.
this witness is concerned, give me one time slot on Thursday and Friday which you can agree on after we adjourn.
Your Honor, please, if I may add as well. In the marking of this exhibit, Your Honor, before the Honorable Clerk of Court, each acknowledgement receipt had 3 signatures. The signature of the Clerk of Court, the signature of one of the representatives for the prosecution, and the signature of the defense counsel, Your Honor. 3 signatures per document. And now they had signed each of these acknowledgement receipts, Your Honor. That's number 1. Number 2, Your Honor, perhaps to restore a level of trust on the side of the defense, maybe we can even use their own documents. If they do not trust the prosecution's documents or photocopies of the prosecution's documents, then we will use their documents, Your Honor, because we are certain that their documents is the same as our documents. Let's use the defense documents, Your Honor. Then they will not say, we do not trust these documents because it is their own defense documents. Maybe that will solve the problem of this court. We will use your documents, counsel. Will you still question using your own documents? Will you still question the authenticity of your own documents?
Of course not, Your Honor.
Okay.
Of
Then
course not,
maybe
counsel.
that is
but
a possible solution, Your Honor. Let us use the defense documents instead of the prosecution documents. Parang wag na tayong mag-compare. Thursday, Friday, manonood pa ako ng Odyssey.
I'm sorry, Counsel. The presiding officer was not yet elected during the pre-trial. Hence, I did not know what went on during the pre-trial. Apparently, the respondent or counsel for respondent has a different purpose and/or intention with respect to the ARs from that of the prosecutor. Therefore, that's why they refused a common marking on the same AR.
Yes, Your Honor.
Is that correct? So they have their own set of ARs, and you have your own set of ARs that was marked during pretrial, correct, counsels?
That is correct, Your Honor.
Now, all that the court is asking is for an opportunity to be had by the parties once more to compare your respective marked ARs to be able to distinguish and find out if indeed they are the same or not, regardless of whatever purpose or theory each party may have with respect to presenting the ARs, given that they are common exhibits. We will not touch into that, counsel for respondents. So your concern with respect to authenticity and purpose will not be touched on. Only insofar as that it is the same AR that you received, it is the same AR that you sent to the COA, that you also have a copy of, that they are presenting. And insofar as ARs that you did not send COA or did not come from you, then you can point that out too, as the case may be or as may be appropriate. Again, without any pressure nor any mandate from the court for you to stipulate on all, just the opportunity to do so. Kindly agree on a date, counsels, on a time rather, between Monday and Thursday. If that is not possible, then we will continue as we have this afternoon. But kindly agree on a date. Court so directs the parties to fix a date and be able to present the same, be present before the clerk of court to compare the ARs they separately marked and to confirm if indeed which ones are the same and which ones are different for whatever purpose it may serve both parties, given that they are commonly marked. So ordered. Hailin, sorry, babalik ka. Wala tayong magagawa. Court will have to wind up at this point because otherwise we will be continuing with this prolonged marking of evidence, which will not only bore the viewing public but the senator judges as well, the presiding officer and the Senate President included. So we will have to cut it short at this point in time and discuss already some administrative matters before we adjourn in time for our session. Yes, Attorney Gabunan.
Just one more ask, Your Honor.
Yes, ma'am.
Earlier in the proposal for stipulation, counsel for the defense was kind enough to stipulate on certain documents, Your Honor, except for 10 documents, Your Honor. Since this opportunity is given by this honorable court to compare, and we understand that their reluctance to stipulate on these 10 documents is because of their claim that it does not faithfully represent the originals, Your Honor. May we ask also that these 10 documents be perused during the period given?
If only to give it a second chance and a second look, given that not much time was given to the counsel for respondents to view it. They were only given 20 minutes. So, yes, the court will allow it to allow the respondents more time to go over it for possible stipulation. Again, no pressure, Attorney Christine. You don't have to if you don't want to. You don't have to if you don't wish to. But the court just wants to give it one more shot to save on the court's time. So ordered.
Thank you, Your Honor.
Now, before the court makes a ruling on the motion for judicial notice, the court promised to hear and listen to the counsel for respondents, either in writing or orally. I have been informed by the clerk that no responsive pleading was given by the counsel for the respondents. So I guess you will be
Your Honor, please.
orally arguing the motion
If I may, Your Honor, please.
beforehand. I guess you will be orally arguing on the motion for judicial notice, counsel. Attorney Christine.
We are ready, Your Honor.
Your Honor,
Again,
please.
just to hear your side. Yes, Attorney Kapunan.
At this juncture, Your Honor, I respectfully turn over to our public prosecutor and head public prosecutor, Chairman Jinky.
Yes, thank you, Honorable Luistro. Before I recognize you, Ma'am Hailin, you are excused. Sorry po. You are excused, but you are ordered without need for the issuance of another subpoena to appear once again before this court on August 10 and 11. 10, so in open court, you are directed to appear here once again on August 10. We will be issuing another subpoena should we require your presence again on August 11 onwards. Do you understand, ma'am?
Yes po, Your Honor.
So magpapakita po kayo sa Lunes uli nang wala ng subpoena.
Yes po, Your Honor.
Salamat po. You're excused, ma'am, and thank you for your presence and cooperation this afternoon and your patience. Now, this won't be oral arguments. The court, the chair just wanted to hear from the counsel for respondents. So really, this will not be oral arguments between the parties. Yes, what is the position of the counsel for respondent in certain records of the House Good Government Committee and Public Accountability Committees, if I'm not mistaken? Attorney Christine, you'll be arguing?
Yes, Your Honor.
You may proceed, ma'am, when you're ready.
Thank you, Your Honor. The defense would like to oppose the motion for judicial notice on the following grounds. Number one, the judicial notice rule cannot be taken of disputed matters. Number two, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the matters covered by the TSNs, the video recordings, and the committee reports. And number three, the proceedings before the HOR, COJ, were questioned by the respondent before the Supreme Court as a fishing expedition and mini-trial. On the first point, Your Honor, judicial notice cannot be taken of disputed matters. In Juan versus Juan, the Supreme Court defined judicial notice in this wise. Judicial notice is the cognizance of certain facts that judges may properly take and act on without proof because these facts are already known to them. Put differently, it is the assumption of a court of a fact without need of further traditional evidentiary support. The principle is based on convenience and expediency in securing and introducing evidence on matters which are not ordinarily capable of dispute and are not bona fide disputed. While the CGGPA and HOR COJ hearings were made public, we do not dispute that, Your Honor. The matters discussed within them, which were documented via the TSNs, video recordings, and committee reports, are not facts automatically admissible in this impeachment trial. Rather, they remain assertions that must be proven by evidence. We note, Your Honor, that Article 1 of the Articles of Impeachment alleges the following: that respondent, Vice President Sara Z. Duterte, committed culpable violation of the Constitution, graft and corruption, and betrayed public trust through the systematic misuse, misappropriation, and irregular liquidation of confidential funds amounting to 500 million pesos released to the Office of the Vice President and 112.5 million pesos released to the Department of Education. Clearly, Your Honor, these are not just statement of facts. These are accusations of misuse, misappropriation, and irregular liquidation of confidential funds, which must be proven by the prosecution through presentation of evidence. In fact, Your Honor, if you noticed, the prosecution in paragraph 1 of its motion for judicial notice admitted that I quote, prior to the transmittal of the articles of impeachment to this honorable court, the House of Representatives, through its Committee on Good Government and Public Accountability and its Committee on Justice, conducted official hearings on matters that ultimately formed the factual basis of Article 1. We highlight that, Your Honor, ultimately formed the factual basis of Article 1, which is the misuse and misappropriation of confidential funds. Okay. Article 1 of the Articles of Impeachment, as a continuation. These proceedings were officially documented through transcript of stenographic notes, or TSNs, official audio-visual recordings, and committee reports. I am just reading, Your Honor, I'm just referring to the motion of the prosecution. Thus, we cannot take the TSNs, the video recordings, and the committee reports as they are, Your Honor, without cross-examining the witnesses of the prosecution. The impeachment court cannot just take the utterances, testimonies, the questions and answers, and the interpellations during the COJ and the CGGPA hearings as factual findings and statements of truth without going through the usual route of evidence, whether these videos are spliced, edited, or shortened, with due respect, and whether the TSNs are accurate and edited or modified as portions of the TSNs turned out to be different to our transcribed notes, which leads me, actually, Your Honor, to my second point. That because the matters covered by the pieces of evidence, Your Honor, which the prosecution would like this court to take judicial notice are exactly the matters that are being heard before this impeachment court, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the TSNs, the video recordings, and the committee reports. The requirement of due process is basic. It is the opportunity to be heard before the court, and affording the respondent the opportunity to cross-examine to cross-examine the authenticating witness serves a dual purpose, Your Honor. First, it validates the existence of the video recordings, the TSNs, and the committee report. And second, it verifies their accuracy and completeness. The Constitution explicitly guarantees the respondent's right to ensure that these pieces of evidence have not been altered, edited, or modified to fit the prosecution's narrative of Article 1. Consequently, the respondent is fully entitled to have all the observations, the objections, and cross-examination questions placed on record before the court admits these documents in evidence. It is also a matter of record, Your Honor, that the videos that the prosecution would like this court to take judicial notice were not played during the pre-trial conference, Your Honor. And it is with the understanding between the parties that there shall be subjected to proper authentication and identification during trial, consistent with the rules of court. And third, the respondent has directly challenged the House of Representatives Committee on Justice proceedings before the Supreme Court, Your Honor, characterizing them as a mere fishing expedition and an unauthorized mini trial, Your Honor. Consequently, the respondent declined to participate in these proceedings, maintaining that the HOR-COJ lacks the jurisdiction to conduct these trials. Under Article 9, Section 3, Paragraph 6 of the Constitution, the respondent submits that exclusive power and authority is vested solely with or in the Senate, Your Honor. That's why a petition for certiorari and prohibition was filed by the respondent before the Supreme Court. So we cannot stipulate, Your Honor, on the matters that were taken up in a proceeding that the respondent challenged before the Supreme Court. But crucially, Your Honor, the petition pending before the Supreme Court challenges the proceedings before the HOR-COJ only and not the actions of the Honorable Impeachment Court. This distinction, however, does not preclude any future legal challenges against actions that this court may take while sitting as an impeachment court. The respondent, Your Honor, was consistent in her position, Your Honor. In fact, In a letter dated March 24, 2026, the respondent through counsel informed the HORCOJ that she cannot attend the mini trial and the fishing expedition being done by the said committee because of the committee's apparent lack of authority under the Constitution. The closing paragraphs of the letter state, and I will read the closing paragraphs for the record. In light of this, while the invitation for the respondent and counsel to participate in the committee's mini trial is well noted, we cannot, however, do so at this point on the ground that the committee and or the HOR, as well as any of its members, lack jurisdiction to conduct any form of trial or exercise any of its incidents. Absent such jurisdiction, any attempt to proceed in the nature of any form of trial or invoke powers ancillary to it is unconstitutional. Consequently, the respondent puts on record her objection to any requests, motions, or similar efforts aimed at obtaining or fishing for supposed evidence through processes that necessarily presuppose the existence of lawful authority and jurisdiction under the Constitution, which in this case is absent. As timely stated in the appearance and consolidated answer, both made ad cotellam, the respondent does not waive any jurisdictional or other objections she has to these proceedings, nor her right to seek the appropriate legal remedies. Nonetheless, she is prepared to meet the charges against her in proper jurisdiction. And because of that, Your Honor, the court must decline to take judicial notice because the very validity and authority of the House of Representatives COJ proceedings are currently challenged before the Supreme Court. Now, on closing, Your Honor, on its face, actually, the motion may look like a plea for this honorable court to take judicial notice of the purported official legislative acts described by the prosecution. However, Your Honor, if you really examine the motion, Your Honor, in reality, however, the motion is actually akin to a public prosecutor, the House of Representatives, asking the criminal court, here the impeachment court, to take judicial notice of the complaint that was filed before the fiscal, here the HORCOJ, and all matters related thereto, including those that transpired during the preliminary investigation without the need for presenting witnesses in court. That is actually what the prosecution is doing in our view, Your Honor. Dahil ang mga pandinig na ito sa House of Representatives ay siya mismong paksa ng paglilitis ng hukumang ito, at ayon mismo sa prosecution, those hearings became the factual basis for Article 1 of the Articles of Impeachment. Nararapat lamang po na ang mga TSNs, video recordings at committee reports na naglalaman ng mga tanong ng kongresista, pati na ang mga pahayag at sagot ng mga testigo ay patunayan ng prosecution sa pamamagitan ng pagpresenta ng testigo upang magpatunay sa katotohanan ng mga ito. In closing, Your Honor, would like to quote the Supreme Court in Juan versus Juan. The Supreme Court said, the article in the website cited by the RTC patently lacks a requisite for it to be of judicial notice to the court because such article is not well and authoritatively settled and is doubtful or uncertain. It must be remembered that some articles appearing in the internet or the websites are easily edited and their sources are unverifiable. Thus, sole reliance on those articles is greatly discouraged. The defense opposes the motion, Your Honor, on identical grounds. Salamat po.
Again, these are not all arguments, counsel. Chair had anticipated the position of the counsel for respondent. In fact, Chair would like to clarify. The Juan versus Juan case is the Lavandera Co case, right?
Yes, Your Honor.
Ito yung Lavandera Co na kumpanya na nireklamo violating copyright standards. Hindi ba na nag-judicial notice yung korte sa isang internet website na may copyright daw yan?
Tama po.
That is the case. Okay, Chair will now make his ruling. First, with respect to the motion to set the conference for marking objected to by respondents insofar as number 3 is concerned. P4-35 to P4-35B, but did not object to the others. So the request for transfer of markings this